I'm attorney Lee Marvin, and today we're going to do a marriage green card webinar to explain basically first of all, the difference between adjustment of status and consular processing. You may have heard those phrases before. A lot of people are like, well, what the heck does that really mean? So that's first thing I want to talk about is what it means for adjustment status and consular processing. Okay. Um, the next thing, I'm looking at, I get messages here every once in a while, so forgive me for that. The next thing I want to talk about is the eligibility requirements for legal permanent residency, aka green card. The third thing I'm going to talk about is the timeline for the processes both inside the United States and outside. Okay. The last thing I'm going to talk about before we go to all the questions and answers is the cost of this process. Okay. So the first thing, adjustment of status versus consular processing. Adjustment of status is what the government calls the process that has the interview inside the United States. Adjusting status, you're adjusting from a non-immigrant to an immigrant. So that's what that means, adjustment of status. And for some reason, they only call it adjustment of status if you're inside the United States doing your green card. Consular processing is getting the green card outside the country, okay? So they call it consular processing because you have to go to the consular office, the U.S. Embassy abroad, and they just call it something different. Part of the reason is because the embassy is run by the State Department, and inside the United States is run by USCIS. So there are two different parts of the government, so they kind of call things a little bit differently, but adjustment status inside the United States, consular processing outside the United States, okay? So that's basically what the difference is. Is as far as the process goes, they can be very different because, again, Department of Homeland Security versus Department of State, they both have their own processes, okay? Every process starts with USCIS. So every process starts with a filing within the United States, and that's the initial petition for alien relative. They still haven't changed the name for that, but a petition for alien relative is what the U.S. citizen or the legal permanent resident files in order to have the right to sponsor their family member. In the context of this presentation, we're talking about marriage base, okay? But that holds true for any relationship, whether it's a brother, sister, a parent, a spouse, or a child, okay? It all starts with the I-130 process, which is the petition for alien relative, okay? That is decided by USCIS. USCIS makes the determination of who you are and whether you have the right to sponsor somebody and whether you meet all the requirements of proving that you have the right to sponsor and that they have the right to be sponsored, okay? That is decided by USCIS. And then USCIS will send that approval, the approval of the I-130 petition, to what's called the National Visa Center if people's processes are outside the country, so that the consular processing can continue with the process. If it's all done inside the United States, USCIS retains control and jurisdiction of that filing. They just continue on with their review. So the I-130 is the first. If they approve it, USCIS will move to the next part, which is usually the filing for the green card request, okay? And then the work permit. So they just continue with the process. If the case is one that they are not allowed to do an interview for, meaning it has to go outside the country for the consular processing, they will send that stuff to what's called the National Visa Center, NVC. The National Visa Center is the office that accumulates a ton more information in order to provide the complete package to the embassy staff to schedule and conduct their interview, okay? So again, slightly different, but they do the same thing. At the end of the day, beginning of the day, end of the day, it's the same thing. The petition starts it, the interview ends it, okay? So the stuff in between is what can change. And I'll go in a little bit more detail when I talk about eligibility requirements, which I will do now. So eligibility, how can one be eligible to get a green card? Well, you have to have a sponsor, okay? The sponsor has to be a relative. whether it's a parent, whether it's a brother or sister, or in this case that we're talking about is marriage-based, okay? So your spouse is sponsoring you. They're either a U.S. citizen or a legal permanent resident. So that is how they're able to sponsor another person for immigration purposes. So the second thing, you have to have proof of a valid marriage. What does that mean? Marriage certificate. The government has changed things on what they will accept and won't accept, but basically proof of a valid marriage. That marriage can be overseas. It could be a marriage in Mexico to Colombia or wherever. As long as it's a legal marriage, the U.S. government will honor that approval and they will use that as evidence to be able to move forward. Okay. So, so valid marriage needs to be shown. And the next thing is the one that is usually pretty challenging for people unless they've planned ahead really well, which is to prove that you have a bona fide marital relationship. Bona fide just means it's legit, it's real, it's a bona fide relationship. So that includes a lot of different things, okay? There's a lot of ways to show that it's bona fide. Relationship together, history of the relationship, kids, you know, different shared things in common. I mean, if that's vacations, if that's living overseas, whatever it is, if you can convince the government that your relationship is real, you got to do that. So it's not just having the marriage certificate, because anyone could, not anyone, but it used to be a thing where people would just create a document, right? It's called fraud. People would create a document and say, this is the marriage certificate in my country. And no, it's not. Okay. So even if you have what appears to be a valid marriage, you still have to show the relationship. Okay. So it's not just a piece of paper, it's also the relationship to show that it's bona fide. Okay. So the next thing that you have to show, if you had a previous relationship, you have to show that you have legally terminated that relationship, that you are legally able to marry another person. Okay. So they're super strict about that. How do you show that? Divorce, easy enough. You show a divorce document in whatever country, and the government can inspect it, look at it, they can challenge you on it, but you have to show that you are legally divorced from your prior relationship. Or death. Okay, death is also a way to show that you're no longer married to someone before. And how does the government know this stuff? Well, because you fill out an application that they ask you about all your former relationships, okay? And then you have to show the corresponding termination of the relationship, okay? So that's another important part. Another one, and this gets asked a lot, which is financial sponsorship. So every time we do an immigration process, we're showing two things. One, that the sponsor is able to be the immigrant sponsor and that they're able to be the financial sponsors. Financial sponsorship requires that you prove to the government that you have historically made enough money to support an immigrant coming to the United States and living for years and years and years, okay? So how do they do that? So there's a list. I mean, the government provides a publication or literature about what the requirements are. They're called guidelines. So they say you have to show that you meet 125% of the poverty line. So you are above the poverty line by 125%. They look at your tax returns most of the time to do that. There's other ways to do it. The easiest way, the quickest way is through tax returns. So technically it's the last year, but in my experience over 11 years, they never stop at a year. They always make you prove 3 years, okay? And if we've had a lot of clients that we've helped that are kind of hit or miss on some of the different years, whether they meet 125% or not, it becomes an art and it's not always easy, but we're usually able to do it, okay? If you can't show those solid 3 years of wages that you've earned that supports your immigrant spouse, there are ways to make that happen, okay? Co-sponsors. So you can get a family member friend, it really doesn't matter who it is, as long as they're a legal resident or a citizen over the age of 18. And you can use their income to show that you meet the requirements, okay? Hugely useful. And I will say that a lot of people need to do that, okay? So it's very common. So the next thing that we have to prove is for the interview inside the United States, you got to prove an authorized or legal entry into the United States, okay? So you enter with a passport, you get an I-94 that shows that you legally entered the country. That's going to be critical to be able to do your interview in the United States, okay? For those outside the United States, you don't ever have to have been in the United States, okay? So you don't have to prove valid legal entry, but you do if you want to have your interview inside the United States. Obviously, in this country, we have decades of people that entered with family members when they were kids or whatever, and they have to show that they enter legally in order to be able to do the interview inside the United States. Now, there are other things that can come up that can allow you to do that if you can't necessarily show your legal entry. We're going to do other webinars about that, but it is possible to do that. But the point is here, you have to show that you legally enter the United States to be able to continue with the process inside the US, okay? So next topic is the processing times, okay? This is a huge hot topic now because of the weird delays and all the problems that people have. Waiting times are in epic levels. So processing times inside the United States. So if you can show that you enter legally and you have the right to apply for your interview in the United States, it depends on where you file from. Each local field office is responsible for the people within their jurisdiction, okay? All their processing times are all over the place. It can take up to 19 months to get scheduled for an interview, okay? We have had people that we've gotten approved in 3 to 4 months. That's not normal. It can be if you do it the right way. And if your facts support the request, it is possible to get an approval within that period of time. But generally speaking, it's between 14 and 19 months, depending on the jurisdiction, okay? So processing times outside the United States, okay. So this is where it gets a little bit more tricky because there's multiple players involved. I already mentioned USCIS. They start the process out. That's the I-130 process. You need an approval from USCIS to be able to move forward with the consular processing. That can take up to 14 months just to get that I-130 approved. Once that's approved, you move to the next step. So in many cases, the next step is just scheduling the interview with the embassy and going through the process with the National Visa Center to provide all the documentation and all the proofs that you meet all the requirements. That can take between 4 and 6 months, okay? From when USCIS sends the National Visa Center the approved I-130 and when the embassy actually schedules the interview. Now, if you've got processes, if you've got a history where it requires some sort of waiver, that completely changes everything as far as timing goes. It can take currently, and we just looked these numbers up this week, 43 months is, I think, an average number for most jurisdictions. Actually, I don't know if that's most jurisdictions, but 43 months is what it's taking now to get a waiver approved. So waiver, again, that's the thing that eliminates the 10-year bar, the castigo, to punish people for either entering without authorization or staying, visa overstay, staying past the time that you're supposed to leave. You are required to get a waiver to eliminate that problem. You do that, generally speaking, before you leave the country. There is a way to do it when you're already outside the country. But if you're in the United States, you're going to want to do it before you leave, so you know whether you're going to be able to have success before you get that 10-year bar, okay? So waivers, again, it's taking over 43 months to get a decision on a waiver. I hope that changes. We track it all the darn time because we've got a lot of clients that we're doing waivers for, but that is a huge waiting delay. So again, step 1 is about 14 months. Step 2, if you have to do the waiver, it could be up to 43 months. The National Visa Center and the embassy, that could be 4 to 6 months before you get that interview. Total processing time can be up to 5 years is the point. So it really depends on your history and what's going on, but that is what it can take, okay? Next topic is the costs for the green card process, okay? So green card costs, there's a lot of different fees that are involved. The initial filing fee for every process, I already mentioned the I-130 is the first part of the process that's applies for everyone, okay? So whether you do the interview in the United States or outside, the I-130 has to be obtained. And the filing fee for that is $535, okay? That's the current filing fee. If you're allowed to do your process inside the United States, then you have the filing fees for the adjustment of status process or the green card request. And that's currently $1,225, okay? So consular processing, the fees are different, okay? It's cheaper if you're overseas because the process takes longer and it's kind of a balance between time and money. So if you have to do your process overseas, it's roughly $550 for the additional fees for that process, okay? Some embassies charge interview fees that you have to pay in local currency, that you have to go to a local bank or some store in the country that's reputable, and you got to pay for the right to get inside the embassy. Some countries do that. Common countries do not do it. Mexico does not charge an additional fee for the embassies. They just charge the consular processing National Visa Center fees, okay? So just keep that in mind. Additional fees always come up with these processes. Examples of additional fees: medical exams. Everyone has to do a medical exam, whether you're out of the country or inside the country. Now, those costs vary depending on the country, of course. Inside the United States, I mean, that's anywhere from $300 to $800. So there's a huge gap in the pricing for that, but you just got to know that you have to plan ahead for that fee too, okay? Passport pictures. So things that support the application that you just have to do, right? Passport pictures, you got to get a valid passport picture, you got to pay for it. Birth certificate, copies of original documents, whether it's marriage certificate, birth certificates, you might have to request those from a foreign government or from the state for which you live in. You have to get copies of that stuff. Document translations, 100% of everything that goes through immigration has to be in English. So we have to do a lot of translations for people. You got to translate that, and the costs are all over the place, okay? So that is a fee that you should think about. And whatever costs for obtaining other official documents. What does that mean? It could mean anything, but most common are getting police clearance letters. For those who have their interviews at a consular office outside the United States, they virtually all require a police clearance letter to show that you're not wanted for anything, that you meet the criminal requirements. So those are additional costs that you might have to get, okay? So let's see here. So I've embedded common questions for this process. I'm gonna read those to you and answer them, and then I'm gonna open it up for people to ask their own questions, okay? Keep in mind that some questions might be best answered in person or a direct communication rather than a group setting. But let me just answer these common questions first. How soon after marriage can a petition be filed? Great question. Immediately is the answer. You get married today, we submit it today, okay? So immediately upon marriage, a lot of people say, well, I heard it's 2 years or more, or this. No. Immediately you have the right to request the petition, okay? But you got to be married first. What if I enter without a visa? Again, this is a very complicated topic. If you enter without a visa, there's things that you can perhaps do that would allow you to move forward the process. Most of the people who enter without a visa, they're going to have to go through their interview outside the country. And I already talked about that and the need for a waiver and all that kind of stuff. So if you enter without a visa, you're going to have to go through that waiver process. unless you happen to have children that are older that can sponsor you through the military. That's another way to get around it. And again, if that applies to you, reach out to me and I can explain that. What happens if I overstay my visa? Another huge question. I spoke briefly about it before, but basically, if you overstay a visa, the government will throw a book at you and they will not be nice about it. That is something that is being strongly enforced by this administration, are visa overstays. If you overstayed your visa, chances are you're going to have to get a waiver when you leave the country to do your interview. Depending on the facts of your situation, we might be able to figure out a way to do it inside the United States. But again, I would need to know the facts and we would have to talk about that, okay? How long do I have to wait after my divorce is final to file a marriage green card? Similar to the first question, you can do it right away. As soon as the ink is dry on your divorce, you're able to move forward to get married and to file for your green card. So there's no time period that you have to show. You just have to show that you're no longer legally married, okay? This is a very important question for a lot of people. Can the children of the new spouse be sponsored for a green card through their step-parent? Yes, it is. It's not as easy, but it is possible. So you marry someone overseas and they already had a relationship. You're showing that they're divorced, but they happen to have kids. As a step-parent, you have the legal right to sponsor your new step-children, okay? It's similar to the fiancé visa. I did a webinar last month on the fiancé and the green card process overseas, and I talked a little bit about that. But just know that you absolutely can sponsor your new children, stepchildren, to come to the United States. There are certain regulations and rules and things that you need to make sure that you meet. So if that applies to you, you definitely need to reach out to me so I can explain it to you. But basically, as long as your child, your significant other is the parent of that child, whether it's through adoption or through birth, then you have the right to sponsor them as well, okay? Huge thing, because it is really hard to sponsor somebody if they're not directly related to you otherwise, but it is a possibility, okay? Please type them in here. Otherwise, schedule a consultation so we can answer questions directly to you without sharing it with the whole world. But thank you again. Everyone have a wonderful day. And don't forget to follow us on YouTube and all of our social media, because there's a lot of good information that I already published. But we will be in touch with you. So thank you for your time and have a wonderful day.